All right, Mr. Weidner, you may proceed when ready, sir.
Thank you, Your Honor. May it please the Court, my name is Donald W. Weidner of the law firm of Weidner and Waterboard of Jacksonville, Florida, and with me at the council table is my associate, Janine Corus. First of all, on behalf of Mr. Beckstrom and the voters of Volusia County, I would like to express our appreciation to the Court for expediting this case and advancing it on the Court's calendar. We realize that the Court has a very crowded docket, and we particularly appreciate the Court's consideration of this matter. It's long been said that our government is a government of the people, by the people, and for the people. That's not just a cliche. The truth of that statement, the truth of that principle, rests on the premise that when we have an election of our leaders, we in fact elect our leaders. It rests on the principle that the results that are announced when the ballots are cast in fact reflect the votes that were cast in the election. If it does not, then we do not have a government that is of the people. Today you are hearing argument in a case that we believe is one of the most important election cases ever considered by this Court. It's important because this case goes to the very heart of the election process, the very integrity of the ballots themselves. Never before has this Court been asked to or been presented with a case where thousands of ballots were unquestionably altered by people other than the voters themselves.
Let me begin by asking you, I believe that the bottom line of what the trial court found was that he did not have jurisdiction because there was not any demonstration of fraud. Would you agree with that?
I would agree that what the trial court ended up saying was he did not conclude there was real fraud, and therefore in his application of
he said, I do not have jurisdiction to set aside the election.
That's correct.
Okay. Now, would you agree that on the issue of jurisdiction of the courts, very fundamentally, that the jurisdiction of the court comes from this 102, Chapter 102.166, Parent 11. Would you agree with that?
Your Honor, there are two sections on jurisdiction. One is the contest section and one is the protest section.
Right. But the contest section in 102.168 is directive as to the fact that as to the contest of the election, and then it says that if the contestant is found to be entitled to the office, blah, 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 in 102.1682. However, the actual provision as far as protests of election returns is in 102.166.
Yes, sir.
And the point of my question really is that in that Parent 11, the language of the statute is that shall have the right to protest the returns of the election or practices attendant thereto as being fraudulent. Okay. And so I would assume, and correct me if my assumption is not in accord with yours, that what Judge Doyle was saying is that since there wasn't any finding of fraud, then he did not have jurisdiction in his court pursuant to this statute.
I believe that that is in fact what he said, and I think he's wrong on the law, because I think under the contest section of the statute, you have the authority, and he had the authority, to set aside this election because there were substantial irregularities, and because of those irregularities, there is no way that we could be certain that the results that were announced were in fact the results.
Point to me in the statute where it says that the circuit court has the power to set aside an election because there are substantial irregularities.
Well, Your Honor, I go to section 102.168, and it says that he can go before the circuit court and shall be the proper party to, let's see, The complaint shall set forth the grounds on which the contestant intends to establish his or her right to such office or set aside the result of the election on a submitted referendum. And I think that it's implicit in that section of the statute that the intent there is that if someone has grounds other than fraud, that you go to the circuit court under the contest and ask that the election be set aside.
Is there any other provision of the statute that would be a basis to set it aside by reason of there not being substantial compliance with the election law?
Well, I think just the next section as well, it says that if the contestant is found to be entitled to the office, the election can be set aside, the one right after the contest, the next one on ouster. And I think those are the two sections of the statute that give this court and gave the circuit court the authority to throw it out. Thousands of the absentee ballots in this case were marked over. They were marked on by people other than the voters who voted them, and they were marked on in such a way that it is absolutely impossible to tell with certainty that the ballots that now exist reflect the intent of the voters who cast them. Now, we can play with semantics, we can play with legal technicalities, and we can play with all kinds of legal arguments. But the bottom line result of this case is that there is no way when this case is over that this court can say to the voters of Volusia County or the voters of Florida that the vote count that exists for the election of sheriff in Volusia County is actually a count of the votes of the people who voted in that race.
Do you agree that you have to get over the burden of substantial compliance?
I agree that I look at this court's decision in Boardman, and this court set down a three-pronged test in Boardman, and I think when you look at that three-pronged test that the election fails. Yes, I think we have to show more than that there is substantial incompliance, and in fact that's what Judge Doyle found in the circuit court.
Well, that was my next question. You feel that his finding of gross negligence would get you past that and irreparable harm?
Absolutely, Your Honor.
That would get you past your burden. Is that your argument?
I'm sorry, Your Honor.
Is that your argument? That would take you, that finding would take you past your burden?
Absolutely, Your Honor. And I want to be sure that the court understands what took place factually in this case in terms of the circuit court proceeding. When we went to the circuit court, we asked for the right to inspect the ballots. The circuit court directed its clerk to set up an inspection process. And for 3 weeks, we sat at council tables in the circuit court courtroom. We looked personally at every one of the 27,000 ballots, but we never touched them because the circuit court clerk's staff handed them, held them up, flipped them over so that we could see them. The integrity of those ballots was maintained by the process that the circuit court established, and I think the clerk in the circuit court deserves special condemnation for the process.
Now, in the 6,000, approximately 6,000 ballots that were remarked.
Yes, sir.
Now, that remarking was essentially done under the guidance, I would say, more or less, of the vendor who sold these tabulating machines, correct? If I remember from reading the record, this representative of the tabulating machines had been down to Seminole County where they had performed the same act of remarking the ballots that couldn't be tabulated by the machine. Then she came to Volusia County. Isn't that correct?
Well, that part is true. I don't think they were there in particular supervising. I guess they were there at the day the ballots were being counted.
Well, they had sold these machines to
Yes.
the supervisor and then went on up to Putnam County and then in Leon County, so that this was not something that was just isolated in Volusia County, this remarking process.
That's correct.
Okay. Now, insofar as the testimony is concerned as to the remarking, give me your best statement as to how you say that the record indicates that this changed the outcome of the election.
Well, Your Honor, I think the best example of that is the language of Judge Doyle himself. He said, I personally inspected several thousand of these ballots, and I find that in the large majority of these ballots, The voter's mark beneath the overmark can be seen. It is a difficult, arduous process, but it can be seen. Unfortunately, in a substantial minority of the remarked ballots, it is utterly impossible to make...
I understand that, but what I'm trying to understand is what it would mean to the election as far as this remarking was concerned, because as Judge Doyle also extensively goes through as to how he determined that it really didn't affect the count and specifically he refers to the fact that there wasn't, as to the remarked ballots, a substantial undervote within those ballots. Isn't that right?
Well, I think what he said, Your Honor, was that as to the remarked ballots, there were a lot of undervotes still existing in the overmarked ballots.
Right.
And he assumes that had there been some kind of fraud going on, there wouldn't be so many undervotes left in the remarked ballots.
Right. Well, what is your theory as to how this remarking changed the statistical percentage?
I think that it changed it substantially because there were a lot of votes that there was no vote in the race of sheriff, and they were marked with a black magic marker for the first time in the supervisor's office. Somebody voted those ballots as they were marking over those ballots. Now, the problem...
That goes to the undervote that Judge Doyle...
Exactly right. And Judge Doyle's problem is, he said, well, but if that took place, there wouldn't be so many undervotes left. The problem with that argument is it wasn't one person marking the ballots. There were dozens of people overmarking these ballots. I don't think every person that was overmarking these ballots was engaged in fraud. But I think there were some people in that office that were engaged in fraud, and I think there were some people in that office that were overmarking blank votes.
I've got one other question for you, and I'll let you talk to these other judges, but what is the standard that if there is to be a determination of fraud, what is the standard? Is it a clear and convincing evidence, or is it preponderance of the evidence, or what would be the basis for a determination on this evidence?
I think it's just a substantial evidence test. I think you look to see whether are you more persuaded or not that there was a problem here. I think when you look at this court's decision in Boardman, you set out a three-pronged test. You said, was there the presence or absence of fraud, gross negligence, or intentional wrongdoing? And clearly, Judge Doyle found that there was gross negligence and intentional wrongdoing. Whether there has been substantial compliance with the essential requirements of the voting law, and he found there was substantial incompliance with the voting law, and whether the irregularities complained of adversely affect the sanctity of the ballot and the integrity of the election. And he said that they did. In fact, where I was reading to you a moment ago, he said, unfortunately, in a substantial minority of the remarked ballots, it is utterly impossible to make any intelligent judgment as to whether the voter's mark lies beneath the black marker over mark or not. These are the ballots that cause the problem. We do not know if the mark is there. And then he goes on to say, since the purpose of the legislature has been completely defeated, it cannot be said that the procedure is a fair substitute to any degree for duplicating a ballot or manually counting it. And then he says this, the question becomes, is this a lack of ordinary care? I find that it is. The question now becomes, is it a want of even slight care so that harm is probable? The answer is yes. I find that it constitutes gross negligence and that the harm would come to the sanctity of the ballot and the integrity of the election. As to the remarking procedure, I find that it does not substantially comply with Florida Statute 101-5614(5) because it provides for no reasonable substitute means of verification of the results of the election, which is the purpose of the statute. And then the real kicker, he says on page 13 of his opinion, I find that the sanctity of the ballot basically means the holiness of the ballot. They were treated here as sacred objects, which is what they are. They were not treated that way by election officials. The sanctity of the ballot was harmed in this election through the remarking process, and I find that harm to be irreparable. Your Honor, I think that probably the best that I can cite you to is Justice Overton's statement in his concurring opinion in Boardman, when he said, "Purity of the ballot must be maintained and opportunities for fraud must be discouraged." If this overmarking process is allowed to take place, there is never any sanctity of the ballot, because the ballot itself is no longer pure. You have no way of ever saying to the voters that the votes that were counted are the votes that were cast.
What would you do in a hypothetical situation where, let's say that we have an election that is, there's a total of 100,000 votes, and you have precincts that are made up of approximately 1,000 voters. Okay, so you've got 100 precincts, and the election is something like 60-40. Okay, for one person as far as the tabulation. But you find that in 2 precincts, you have this kind of conduct there. Now, the total number of votes in those 2 precincts is 2,000 votes, right? So they couldn't have made a difference in the outcome of the election. But you've got this kind of conduct. Now, what would be the outcome, in your view, if there was a challenge to that election, where it's limited to 2 precincts, but you had that conduct, and therefore these observations, of course, would be absolutely correct. That is, that the integrity of the ballot in those 2 precincts, based on this kind of a record, clearly would be demonstrated to have been disturbed, and that you couldn't.
Yes.
In other words, you couldn't feel very good about those 2 precincts without any question. Of course, the trial court has used rather strong, and obviously the trial court here is very frustrated too, in the sense perhaps of remedies available. But take that hypothetical for me. You've got apparently a clear outcome, really wouldn't have been affected, by just those 2 precincts. What is your view, under the law that we have, the statutory scheme and this court's case law, of the outcome of an election like that?
Your Honor, I think in that case, the ballots in those 2 precincts would have to be thrown out, and you look at the votes that remain and decide the election. And in this case, if you throw out the overmarked ballots, if you don't, just throw those out, Mr. Beckstrom wins. If you throw out all the absentee ballots, Mr. Beckstrom wins. Now, the only problem I have with your hypothetical is you understand that at the polling places, the voter is there, and the ballot is put in the machine right then, and they see whether it reads it. It's only in the absentee ballot, when the voter is not present, that this kind of problem takes place, this kind of destruction of the integrity and purity of the ballot.
Well, here, the concern that I have, you see, is that the trial court, in his concluding paragraph where he actually makes a conclusion here, he says, "We do have a full and fair expression of the will of the people. Vogel won it." In other words, obviously, the trial court is making a determination here that there weren't sufficient mismarked, overmarked, whatever, disturbed ballots that would have made a difference here. Is that what he's concluding, you feel, or not?
Your Honor, I think that's what he's concluding, and that's part of the problem, is that that's where his conclusion is wrong, because what he did...
Let me stop you right there, though, for a minute, because that's very important. Okay. In other words, you're saying that there's no evidentiary basis on the record that we have for him to make that conclusion.
Absolutely correct, Your Honor. There is no way that conclusion comes from the evidence in this case.
And that's the key, really, to the resolution of the case, in your view.
That's right. In fact, his own opinion makes it very clear that he said, "I personally inspected thousands of the ballots, and there was a substantial number of those ballots where I could not see that there was any voter mark underneath the black overmark." Well, if you can't see that it's there, there's no way that you know that you have an accurate count of votes that were cast. You have an accurate count of marks on ballots, which ought to be the count of votes that were cast. But in this case, you don't have a count of the votes that were cast.
Well, even in that situation, if you had the uncontradicted testimony of those people that earlier examined, for instance, ballots, and said, well, I, took an oath and whatever, and then I examined these ballots, and all I could find I found on these ballots a clear mark, but it wasn't enough of a mark for the computer reader to read that. And I swear under oath that I marked that in accordance with the clear mark, that was on there. Notwithstanding the fact that a later examination of that cannot make out, that the underlying mark, was still there. Now, if that was the uncontradicted evidence in the case, would you throw out that ballot?
Yes.
You would.
I would throw out the ballot for one very simple fact, Your Honor. Our election process is set up to make sure that the integrity of the ballot is always paramount. And the minute you screw around with the integrity of the ballot, then you throw out all possibility of ever verifying election results. You make it impossible for us ever to know what really took place. Did some of those people lie when they testified that they marked over ballots and they only marked over votes that were there? I think some of them did. Who? I don't know. But I think the statistical evidence in this case makes it absolutely clear that there were shenanigans going on. Some of them may have just been by accident. They were sitting there marking ballots as fast as they could mark them, and they mark over an undervote where there was no vote taken. Could have happened by accident too.
Let me ask you one last, and I'm going to ask the Chief's indulgence that he'll give you a couple of minutes for rebuttal because of my questions here. If you had to pick out one single piece of evidence or testimony that you think was most indicative of fraud happening here, what would be that single piece of evidence or testimony that you would point out to this court?
Well, Your Honor, I don't know that there's a single piece of testimony.
What's the strongest, piece of evidence or testimony?
I think there are two classes of that. The first one is that every one of the statistical experts, theirs and ours, that looked at the ballots and compared all the good ballots, the ones that there's no question about whatsoever, and compared them with the statistical result of all the overmarked ballots, said that for some reason these overmarked ballots are dramatically different than the good ballots. They're statistically different in a way that couldn't happen by random. The chances are 1 in multi-millions that it could happen by random. All the experts agreed. And their expert and our experts also agreed on this. We don't know how that happened. It could be fraud. Maybe there's some other explanation. We don't know. But we can't rule out fraud. And the second thing is when you look at, admittedly, a small number of ballots, but you look at some of the ballots that we pointed. There were 25 ballots where every race was marked over except a vote for Mr. Beckstrom. There were only 2 ballots, or 3 ballots, where that took place, where the vote that wasn't marked over was a vote for Mr. Vogel. There were ballots the other way, where the only race that was marked over was the sheriff's race. 15 times they were marked over for Mr. Vogel. Never did we find a ballot where all the races were left unmarked except a vote for Mr. Beckstrom. There was something going on, but the bottom line is I don't think this court has to go to fraud issue. I think the court looks and says the sanctity of the ballot has been destroyed. When you screw around with the ballot, when you destroy its purity, you destroy the election.
All right. Mr. Weidner, let me do this. I'm going to add 2 minutes onto your time for rebuttal later, and I'll also give 2 minutes additional to the other side. So, Mr. Marshall, if you'll keep time on that. Okay, let's see. I believe Mr. Eckert is going to argue first.
Sure. May it please the court, my name is Daniel Eckert. I represent the Volusia County Canvassing Board. With me at the table is James R. Clayton, who represents Mr. Vogel individually. Your Honor, I think the key finding in this case is by Judge Doyle on page 3 of his judgment, which I believe appears at record 714, when he says that if qualified electors cast the absentee ballots, they express the will of the people. I find no evidence on which to conclude that anyone other than qualified electors cast to challenge absentee ballots. Therefore, they express the will of the people to which the judiciary must respect and to which the government must submit.
Well, let me focus you, Mr. Eckert, on the facts here on the remarkings. Don't you have to concede that that was not substantial compliance with the statute? In the statute, it says, in respect to absentee ballots on the canvass of the returns, and under 101.5614, paren 7, absentee ballots may be counted by automatic tabulating equipment if they have been punched or marked in a manner which will enable them to be properly counted by such equipment. These ballots had not been marked in such a way that they could be calculated by that automatic tabulating equipment, and so didn't they have to be manually counted to be in compliance with the statute?
Well, Your Honor, I think the sentence which applies is probably the let me go to your question first. I think probably we concede in hindsight that the statute was not complied with, that there was a misinterpretation, a consistent administrative misinterpretation of the statute, but not a fraudulent one or an intentionally wrong one.
Well, if setting aside the issue of intentional fraud, which I find it would indicate that Judge Doyle had indicated there was no evidence upon which he could conclude that there was intentional fraud. What about constructive fraud? The fact that if there is not a compliance with the election law, that would indicate that people who had voted, that their actual votes were not counted in this process, and that would subject those votes to substantial doubt as to how those votes would have been cast, then why isn't that what we would conceive in the law as constructive fraud?
Well, I would like to continue to address the question you asked previously, because I think that the sentence says that they may be, the sentence which was relied upon says that they may be duplicated or hand counted, and that the statute continues and says no vote shall be declared invalid or void if there is a clear indication of the intent of the voter as determined by the Canvassing Board. And likewise, as going into the election, I think it was a fair interpretation that under subsection 7 of the statute, that statute by its terms it seems to deal with precinct ballots, and going into the election, into this trial, I think it was a fair interpretation to say that subsection 7 applied, and that would, the regularity, the consistency of administrative process here negatives any intention of fraud. To your specific question, this court has said on a number of occasions that if there is a full and fair expression of the will of the people, even though there may be misconduct, even willful misconduct, as Karn says, by elections officials, the voters will not be deprived of their vote. What counsel is advocating is that 1 out of every 6 voters in Volusia County be deprived of their vote. And this court has been said, I think probably one case that I overlooked in the preparation of the brief speaks to that, and it was discussed by Mr. Clayton during the closing argument, is Coleman versus O'Neill. In Coleman, the issue concerned poll ballots which had not been continuously kept inside or possession of the election inspectors. The court found that there had been a lack of appreciation by the precinct inspectors of the responsibility reposed on them, and a careless disregard of their duties, almost a breach of trust. Yet the court found no fraud and held that the voters in that precinct concerned should not be disenfranchised.
Would you agree that the sanctity of the ballot can be compromised short of actual fraud? Would you agree with that?
Well, yes, I think that Judge Doyle found that the sanctity of the ballot in this case had been harmed, but it had not been destroyed. He meticulously went through probably 4 or 5 days himself, as I recall, inspection of these ballots, deriving impressions that he was entitled to gather as a trier of fact. He found, on the basis of the inspection of the ballots and on the live testimony and on the statistical testimony, his evaluation of the demeanor and on certain things that are set out in the, such as the undervote statistics, the overvote,
Well,
that there was no.
Could gross negligence in the handling of the election affect the sanctity of the ballot?
Well, this is an election contest statute, and the purpose here is to determine who was the winner of that election that day. And what he found is the election officials erred. Maybe he found that the statute was ambiguous, giving them the benefit of the doubt. He found that they were erred.
Well, he found gross negligence, didn't he?
Yes, sir, he did. He did. But he found that the votes cast were those that were counted by the clerk, and that the errors that one of the errors of gross negligence was in programming of the machines. That error was wholly corrected by Judge Doyle's finding by the manual recount, which had not been requested for whatever reason by appellant of the elections officials. But the programming, that error was wholly corrected. Then the question became, well, the integrity of the election and the sanctity of the ballot, which he found to be damaged by a process that he said, you know, really, I think what Judge Doyle is saying is I ought not to be put in this position of having to go through and gather these impressions. They ought to be self-evident. But I have. And I've made these findings, and I find no fraud. And consistent with the case law of this court of over a century, voters are not to be disenfranchised because of errors of elections officials, even if they had the best of intentions to begin with, as it was in this case.
Well, so it's your position that the only way that the court can set aside an election is with a finding of intentional fraud? Is that your position?
No, I think that there has to be what Judge Doyle found in this case not to exist, a reasonable probability that the result of the election was changed, and he disclaims that finding in his opinion.
Well, once we get to a point, if you get to the point where you find that there's substantial noncompliance with the election law, then why doesn't what this court said in Bolden take over? And where it said to require evidence which would establish with mathematical certainty the specific number of invalid votes sufficient to change the result of an election would make the task of setting aside an election because of intentional fraud or corruption virtually impossible, particularly in metropolitan areas. Now, why isn't it, once you find there was substantial noncompliance with the election laws, why would you get into trying to figure out how many votes that actually corrupted?
Well, because he found in this case that the process lent itself to corruptibility, but it did not occur. Bolden is, to me, a restatement in the converse of what this court had said in Karn some years earlier. It said, the Bolden case says, we held that a fair election is a paramount consideration, referring to Boardman. The opinion states, we reiterate our previous statement, the courts must not interfere with an election process when the will of the people is unaffected by the wrongful conduct, which is what Judge Doyle found in this case. But
what do you do with the finding, or was counsel correct when he stated that all experts agree that there was a statistical improbability in these strikeovers? Do you agree that the experts made that finding?
Well, what they said was that the remarked ballots were not a random sample of the absentee ballots, and likewise the absentee ballots are not a random sample of the total overall set of ballots, and nor should they be. Random means equal chance of being rejected. And when the voter uses an instrument other than that which he or she has been directed to use, that is not, when those ballots are rejected, it's not a random chance. That's what Judge Doyle found.
Well, I thought that the expert opinion was that there were 58.9% of the uncontested votes, absentee ballots that went for Vogel, and of the contested the remarked ballot 62.9%, and that went for Vogel, and that variance of 4% was a 1 in a million chance. Wasn't that what, at least that's what the one of the experts said?
I don't recall the 1 in a million chance being directed to that
4% variance.
to that 4% variance, but it's fair to say that they said it could not occur as a random sample of that it was beyond normal statistical variance. But the 58.9 to 62.9 was testified to by Dr. McClave, our expert, who said that could easily be explained by a series of demographic factors which were present in the absentee ballots. And the other expert who did not use the 1 in a million, as I recall, Dr. Ayers, agreed that what he said was that the remarked ballots were systematically different, and he agreed that demographics are a system which can affect the ballots.
When you couple the statistical improbability, no matter how it's phrased, with the court's finding of gross negligence, don't you get pretty close to impacting upon the sanctity of the ballot at that point? Or can you just ignore that and what do you do? Everybody's saying that, well, this is almost impossible for this to happen. And then the judge finding that there's gross negligence, but I can't find fraud. He stopped short of finding fraud. Is that the end of the battle there? Or isn't there, don't you have to look a little further when you have that scenario?
Well, the testimony in that regard was that the statistical variance between the remarked and the other absentee ballots did not, while as a total, if you throw out all the remarked ballots, it would affect the result of the election. But all the experts agreed, at least those that were asked, Dr. Ayers and Dr. McClave, that if you applied the same percentage of the rest of the absentee ballots to the remarked ballots, that the outcome remains the same.
If you throw out the ballots that were struck over, but you couldn't tell from the original whether there was an original check or not, would that affect the results of the election?
Well,
do you understand what I'm asking?
I think I do. I'll try to address myself to it and then yield to Clayton. I think that the closest place that you find that expression of the record is on page 577, where the campaign manager for Mr. Beckstrom testifies that the C's and the D's were set aside, and which are counted in the on the clerk's tally sheet on record 319 and 20. That if you just throw out those, whether they felt that the remark was not apparent, that does not affect the result of the election. It's
that
only
would not affect.
There's 360 versus 175, as I recall, or 185, and that if you just throw out that set of ballots. Now, I want to be clear that Judge Doyle did not make a specific finding that those ballots were the only ones on which you could not see the vote underneath. Thank you. I'll yield to Mr. Clayton.
Mr. Clayton.
Thank you, Your Honor. May it please the court, I'm James R. Clayton here on behalf of Robert Vogel, who, not Sheriff Vogel, but Bob Vogel, the candidate, the successful candidate who was an indispensable party pursuant to 102.168. I would ask the court to look at or consider 102.166, the last paragraph regarding when there is no fraud, but it indicates the circuit judge to whom the protest is presented shall have authority to fashion such orders as he or she may deem necessary to ensure that such allegation is investigated, examined, or checked, to prevent or correct such fraud, or to provide any relief appropriate under such circumstances. While this might not be a case of first impression because there's been a century of case law involving election improprieties, this certainly is an unusual case in that the clerk of the court, at the direction of the Judge Doyle, literally counted every single absentee ballot. I think it's important to note the sequence of events. The so-called remarking procedure occurred days before the election. One would think that if there was going to be a fraudulent remarking, they would have known the outcome of the precinct election. The remarking procedure started before Tuesday and was completed before the general election. The voting process then goes through the precincts, they tabulate them, then we go into the lawsuit. This election was not decided until all 27,000 votes were counted by the clerk of the court. The clerk of the court filed a recap of every single absentee ballot. It's found in the record at 319 and 320. It was filed the day of the beginning of the trial and makes references to C and D boxes, which I believe was what Judge Doyle was referring to as the substantial minority of those where you couldn't see if there was one of the mark was underneath the remarking process. While we might not agree with this remarking process, and while in hindsight it seems to be, leaves a lot to be desired, we now know, after all the testimony, every single person that remarked a ballot took the stand and testified that they marked what was there. In fact, after the recount, interestingly enough, because of the way the machine was calculated, 1,000 votes were left uncounted. Those people would have been disenfranchised had Judge Doyle not asked the clerk of the court to look at every vote. What Mr. Beckstrom's trying to do is disenfranchise just enough people to where he can win. He started off trying to disenfranchise 27,000 votes. I just can't comprehend this court literally setting aside 27,000 votes or any portion thereof, knowing that every single person that remarked a ballot testified, and the clerk of the court counted every single one.
Let's recap that in that event, that to get our statistics in our mind, that if just the ballots that were remarked were held to be illegal, then Mr. Vogel would not have won. Is that correct?
Correct.
If to the remarked ballots, those 6,000 votes, if the same percentage of those votes, 58.9%, were given to Vogel that he had in the uncontested, then who would win in that regard?
Got my pocket calculator with me.
Isn't there expert testimony in the record?
The expert testimony regarding the statisticians, is that what the court's referring to?
What I'm saying is if Vogel had received 58.9% of the marked over ballots, would he have won?
I believe so, Your Honor. It's my understanding, yes.
So if the percentage had been the same?
Yes.
What significance do you put on the testimony of those who did the marking over, coming before the court, and then testifying that I did not commit fraud?
I think that's very...
Do you really, could you expect them to come forward and say, yes, I intentionally committed fraud?
Judge, it was a very lengthy trial, and the burden of proof fell on the plaintiff. They called every single person. Judge Doyle, as the trier of fact, made a decision that based on all of the testimony before the court, and it wasn't just those people that testified, there was people that tried to infer fraud, and the judge found that they were not credible. So yes, That's, I guess, the problem with our judicial system. The trier of fact, whether it be a jury or whether it be the judge, has got to decide based on the personal observation as who to believe and who not to believe. So the trier of fact in this case, Judge Doyle found that in fact there was no fraud and that the free, fair, and expression of the people had been determined after the clerk of the court counted it. I think we'd be in trouble if the clerk hadn't counted those votes. But the fact that the judge came in and looked at every single absentee ballot, we now know what the free, fair, and full expression and the will of the people is.
That's what the expert.
And it'd be very difficult to ignore that. So Judge Doyle made a determination that, yes, they were credible. And again, I repeat, this remarking process was done before anybody ever knew of the precinct's return. In summary, I would just state that I cannot stress enough how Judge Doyle, even though he did decide that the sanctity of the ballot and the integrity of the election had been harmed, it had not been destroyed. And while it might have been indicated that it was irreparable, we believe that the clerk of the court salvaged this election. It's a very tedious, lengthy process. And this court, back in 1936, in a Volusia County case, in fact, Peacock versus Latham, State Ex Rel Peacock versus Latham, the circuit court had inspected the ballots. So I think that the statute allows Judge Doyle to go in and do this. He shouldn't be required to. Shame on the supervisor of elections for putting us all in this position. But we can't throw out 27,000 votes after we now know what they were. Thank you.
Thank you, Mr. Clayton. Mr. Weidner, you have 2 minutes, sir.
Thank you.
Mr. Weidner, wasn't the testimony in the record that if Vogel had received the same percentage of the contested votes that he received in the uncontested absentee votes, he was still won by 600 votes?
I believe, in fact, there was such testimony, Your Honor, but that's really not the issue, because the fact is, of the marked over ballots, we don't know how those ballots would have been cast.
I just was concerned about what the testimony.
You're correct, Your Honor. And I think the first thing that I want to point out to the court is that the question about these people coming forward and testifying, well, I didn't mark over any ballots, as Justice Shaw pointed out, I can't imagine somebody coming forward and saying, yes, I committed fraud. But more importantly, there is absolute evidence in the record that marked over ballots were marked over improperly. If these people marked over all the ballots correctly, you wouldn't have the hard evidence before you where you have ballots that have been marked where the sheriff's race is not marked over when it's a vote for Mr. Beckstrom, and ballots where the only vote that's marked over on the whole ballot is a vote for Mr. Vogel. You wouldn't have those things if these ballots were being marked over properly. So there's already evidence that the mark over process didn't take place the way it was supposed to.
Well, let me ask you this, though. The trial judge in this case concluded that the evidence did not sustain a finding of fraud and did not sustain a finding of intentional wrongdoing. Am I correct?
You're correct, Your Honor.
Now, are you basing your argument at this stage on the matter that there was a finding of gross negligence?
Your Honor, I'm basing my argument on the fact that the circuit judge looked at those ballots and he said, as a finder of fact, I personally expected thousands of these ballots, and there are any number of them that I can't tell there was a voter's vote before that overmark. Now, I don't care whether you call it fraud, gross negligence, or whatever you want to call it. When we have an elections process where when the election is over, we can't tell the voters we counted the votes that voters voted, there's something wrong with the election. And that's the problem with this process. We do not have a count of the votes that were cast by voters in Volusia County for sheriff. We have a count of ballots that are marked with magic markers. We don't know what the vote was underneath. And when Justice Shaw, I believe you asked, well, if you looked at the ones where you could not tell that there was a vote underneath, what would the result be? And the answer to that question is we don't know, because as Judge Doyle pointed out, this isn't a simple process. It's not one where you look at it and say, yep, there's a vote underneath, or no, there's not a vote underneath. There were ones that we'd study for hours, and you'd turn them sideways and hold them to the light and look at them this way and look at them that way, and you still can't tell whether there's a vote underneath or not. And that's the problem with this process. The ballot process must be maintained. The integrity of the ballot must be maintained. When you destroy the integrity of the ballot, you destroy the election.
Thank you, Mr. Weidner.
Thank you, Your Honor.
All right, thank you, counsel. Court will be in recess until tomorrow morning.
Please rise.